Would you raise your hand, please? Do you solemnly swear the testimony you're about to give in the matter now pending shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Would you please state your full name?
I'm Jeffrey Edward Epstein, and my residence address is 6100 Red Hook Boulevard in Virgin Islands.
Have you ever been convicted of a crime?
Yes.
The sex crimes of millionaire financier Jeffrey Epstein are appalling.
I was unaware that I was going to be alone with him. I thought I was going to die.
More than 100 vulnerable teenagers and young women trapped in his depraved web.
He started touching himself.
Tonight, the Epstein Files, the latest on who knew what in the biggest sex trafficking ring in history. His elite circle of the wealthy and powerful on notice as thousands of damning new court documents are unsealed.
They will contain the names of people associated with Jeffrey Epstein.
Prince Andrew and the former President Bill Clinton have been named.
More are expected to come out.
In the last few weeks, they've linked Epstein to some very famous names and exposed some very sordid details.
There are videos that exist.
We've been investigating this scandal since Jeffrey Epstein's death in 2019. This is where Jeffrey Epstein served his sentence. That he can still shock is extraordinary.
I won't stop fighting. I will never be silenced.
As you'll see, this monster's tentacles continue to reach from beyond the grave.
For years, the name Jeffrey Epstein has hovered over headlines like a shadow that refuses to fade. Courtrooms went quiet, documents were sealed, and yet the story never ended. It only waited. Then, without warning, thousands of pages of legal records resurfaced, dropping into the public space like a loaded weight. Names, dates, connections. Not answers, just enough information to reopen wounds and raise the same unsettling question people have been asking for more than a decade. What are we still not being allowed to see? What most people call the Epstein Files aren't a single secret folder hidden in a vault. They are fragments of lawsuits, depositions, emails, flight logs, and court exhibits spread across years of civil litigation. Many of them come from a case filed by Virginia Giuffer, one of Epstein's most prominent accusers, who said she was trafficked to powerful men while she was still a teenager. Her lawsuit wasn't a criminal trial. It was a civil case. And that difference matters more than most people realize. Epstein didn't start out as a monster in the public eye. He built an image of wealth, intelligence, and influence. He moved easily through elite spaces, private planes, exclusive islands, billionaires' homes. He donated money. He hosted important people. And for a long time, those doors stayed closed to scrutiny. The power imbalance was baked in from the start. Young girls with no influence. A man surrounded by lawyers, money, and protection. There were warning signs early on, quiet settlements, victims paid to stay silent, a controversial plea deal in 2008 that allowed Epstein to avoid federal charges and serve minimal jail time. That deal didn't just end a case, it buried evidence. Records were sealed, testimony was locked away, and the public was told the matter was closed. But it was. Years later, as civil cases continued, judges faced a problem. The records contained sensitive details about victims, witnesses, and third parties who were never charged with crimes, so they approved redactions, black bars over names, pages sealed entirely, legally justified but devastating to public trust. Every blackout fueled suspicion. Every release felt incomplete. When Epstein died in jail in 2019, the criminal case against him ended instantly. No trial, no verdict, no final accounting. What remained were the files, still sealed, still redacted, still legally tangled. And every time a new batch was released, outrage followed. Not because the documents revealed everything, but because they clearly didn't. And buried in those pages was proof that the full story was never meant to be seen all at once. If this already feels unsettling, it's about to get worse, because the next chapter reveals how these documents actually became public, and why their release was never guaranteed in the first place. Like the video, subscribe to Crime Decoder, share this with someone who still thinks the Epstein story is over, and drop a comment. The reason these documents exist at all comes down to a legal path most people don't fully understand. After Epstein's criminal case stalled, civil lawsuits became the only way victims could force answers into the open. Civil court doesn't decide guilt the way criminal court does. Instead, it decides liability. That difference is why so much information entered the record without ever being tested in front of a jury. In civil discovery, both sides are required to share evidence. Emails, depositions, internal records, travel logs. That process creates mountains of paperwork, much of it never intended for public release. Judges can seal documents to protect privacy, prevent harassment, or avoid harming people who are not formally accused of crimes. In the Epstein-related cases, judges did all three. One of the most important figures in this phase was Virginia Giuffre. Her lawsuit against Ghislaine Maxwell forced open years of sealed material, but even then the court didn't simply dump everything online. Each document had to be reviewed line by line. Names were evaluated. Context mattered. Some people mentioned were already public figures. Others were private individuals. Some names appeared only once without evidence of wrongdoing. The court's job wasn't to satisfy public curiosity. It was to follow the law. That legal caution is where frustration exploded. Every time a document was released, it felt like someone had taken a marker and erased the most important parts. Names replaced with initials, entire pages missing, references that led nowhere. To the public, it looked like protection. To the court, it was procedure. And then there was timing. These files didn't surface because someone suddenly chose transparency. They came out after years of motions, appeals, and pressure from media organizations, arguing that the public had a right to see what was already discussed in open court. Judges didn't agree all at once. Some releases were delayed for years. Others were staggered in batches, ensuring the story never arrived whole, only in fragments. When people read these files, many assumed they were reading proven facts. But depositions are sworn statements, not verdicts. Allegations appear next to denials. Names appear without charges. And once Epstein was dead, there was no criminal court left to sort truth from accusation. That vacuum created something dangerous, a mix of verified records and unresolved claims, circulating without a referee. The documents were real, but the conclusions were left to the reader. That's why the same names triggered outrage online while no charges followed. The legal system and public expectation were no longer aligned. And behind all of this sat one uncomfortable reality. Some information can only be revealed through a criminal trial that never happened. In the next chapter, we're going to walk through what these files actually contain, what they do not contain, and why confusing the two has reshaped the entire Epstein conversation. Like the video, subscribe to Crime Decoder, share this with someone following the Epstein story, and leave a comment. When people finally opened the Epstein files, many expected a clean list, names on one side, crimes on the other. What they found instead was something far more disturbing and far more confusing. The documents didn't deliver closure. They delivered context without conclusions. Most of the material comes from depositions. These are sworn statements given under oath, often behind closed doors, long before any judge or jury weighs in. In these statements, accusers describe what they say happened to them. Witnesses describe what they claim to have seen. Lawyers ask questions designed to protect their clients, not uncover moral truth. That means the files contain allegations, denials, second-hand accounts, and references to people who were never accused of committing a crime. This is where public perception fractured. A name appearing in a deposition does not mean guilt. Sometimes it means someone attended a party. Sometimes it means they were mentioned in passing. Sometimes it means an accuser claimed something that was never tested in court. The files rarely provide full context. They assume a legal reader, not a viral audience. The most explosive reactions came from flight logs and contact lists. Epstein's private planes flew often. His address books were full. Powerful people crossed his path because he made it easy to cross his path. That overlap between access and accusation became fuel for speculation. Social media collapsed all nuance into a single assumption: presence equals participation. But legally, that assumption doesn't hold. Another layer that complicated everything was redaction inconsistency. Some names were blacked out in one document but visible in another. That wasn't favoritism, it was timing. Different judges, different rulings, different privacy arguments. To the public, it looked chaotic. To the legal system, it was procedural. Then there's what's missing. Entire sections remain sealed, not because they name powerful people, but because they contain identifying details about victims who never asked to be public figures. Judges have repeatedly stated that protecting victims outweighs public curiosity. That protection, however, came at a cost. It deepened the belief that something darker was being hidden. Epstein's death intensified that belief. With no criminal trial, no cross-examination, and no verdict, the files became the only remaining artifact of the case. They weren't designed to carry that weight, but they were forced to. And as the documents circulated, something irreversible happened. The public began treating legal evidence like a puzzle meant to be solved online. Names trended, reputations shifted, but the courts stayed silent, bound by rules that don't move at the speed of outrage. The truth is uncomfortable. The Epstein files reveal how much power, money, and secrecy can distort justice, without actually delivering justice themselves. Next, we'll look at the final stage of this story. What happened in court after these releases, why accountability stalled, and why this case still refuses to end. Like the video, subscribe to Crime Decoder, share it with someone digging through these documents, and drop a comment. By the time the Epstein files reached the public, the courtroom battles that created them were already winding down. There was no dramatic trial waiting at the end of the road. No moment where a jury would sit, listen, and decide who was telling the truth. What followed instead was a quiet legal conclusion that felt deeply unsatisfying to anyone hopping for accountability. Ghislaine Maxwell's criminal trial became the closest thing to justice the system could still offer. Prosecutors focused narrowly on what they could prove beyond a reasonable doubt: that Maxwell helped recruit, groom, and traffic underage girls for Epstein. The case did not attempt to prosecute every rumor, every name, or every connection in the files. It stayed focused, almost painfully so. In 2021, Maxwell was convicted. In 2022, she was sentenced to 20 years in federal prison. For many people, that verdict felt too small for the size of the scandal. Epstein himself was gone. Legally, his case died with him. No posthumous trial, no public testimony, no cross-examination of witnesses. Civil cases against his estate resulted in settlements, not findings of guilt. Money changed hands. Survivors received compensation, but settlements are not confessions. They are closures without answers. The courts repeatedly emphasized a hard truth: the legal system cannot prosecute rumors or public suspicion. It can only act on evidence that meets a strict standard. Many of the names discussed online never crossed that threshold. Some were never investigated. Others were investigated quietly, with no charges filed. And without charges, there would be no public explanation. This silence widened the gap between law and public trust. Families of victims spoke about relief mixed with frustration. They were heard, but only partially. The broader community reacted with anger, disbelief, and a growing sense that power still shields itself. Every new document release reopened wounds rather than healing them. Judges acknowledged the public's interest but stood firm. Transparency, they said, does not mean exposure without limits. The law moved slowly, deliberately, and without emotion. The public moved fast, fueled by outrage and unanswered questions. And so the Epstein case settled into a strange afterlife, officially closed, emotionally unresolved, legally documented yet morally unfinished. In the final chapter, we'll confront the question that refuses to disappear. If the legal process has ended, why does this story keep coming back? And what does that say about justice itself? Like the video, subscribe to Crime Decoder, share it with someone who still feels this case never truly ended, and leave a comment. Long after the courtrooms emptied and the headlines moved on, the Epstein files remained, not as a finished story but as a reminder of something broken. Officially, the legal process reached its end. Epstein is dead. Maxwell is serving time. Civil cases are settled. On paper, the system did what it could. But emotionally, culturally, and morally, the case never found an ending that felt complete. The reason this story keeps resurfacing isn't because of new crimes or new charges. It's because the files expose the limits of justice when power, wealth, and secrecy collide. They showed how much of the truth can exist without ever becoming legally actionable. How victims can speak under oath and still never see a full public reckoning. How documentation can survive while accountability does not. Every time a new batch of records is released, the same cycle repeats. Outrage, speculation, disappointment. Not because the documents are empty, but because they confirm what many already feared, that the system is built to move carefully even when the public wants speed. That protecting due process often means withholding emotional closure, and that once a central figure dies, entire avenues of truth close forever. Judges have been clear. More releases are legally possible, but they will be limited. Names alone will never equal justice. Without new evidence that meets criminal standards, the courts are done. The law has reached its boundary. What remains is public memory and mistrust. For survivors, that reality is heavy. Some have said being believed mattered more than verdicts. Others still feel robbed of the chance to face the people they say abused them. Their stories exist in records that may never be fully unsealed. Their trauma is preserved in footnotes and redactions. For the public, the Epstein files became something else entirely. A symbol, not just of one man's crimes, but of how systems protect themselves. How influence blurs lines. How truth can be fragmented, delayed, and diluted until it no longer satisfies anyone. And that's why this case refuses to fade. It isn't about Epstein anymore. It's about trust, about whether justice feels real when it arrives incomplete, about whether transparency matters if it comes years too late, and about how many other stories may never surface at all because they don't have the spotlight this one did. The Epstein files don't give us answers. They give us a mirror, showing what happens when accountability depends on timing, survival, and power. So here's the question that lingers, long after the documents stop coming. If the legal system followed the rules, but the public still feels cheated, was justice ever truly served? If this video made you think, drop your answer in the comments. Like the video, share it with someone still questioning this case, subscribe to Crime Decoder, and turn on notifications so you don't miss what we decode next.